I'm good to go.
This is case study number 1, and we are group 9. How do these terms apply to the case? A disparate treatment. Demur was discriminated against because of his religion, which happened to be heavily practiced among the African American community in the area. Requirement to accommodate. Jenkins was required to accommodate Demur's requested vacation time for religious reasons, regardless if their beliefs are in line with each other. Harassment, coworkers leaving voodoo dolls, other objects, and notes in his office upon his return to work following the retreat is harassment. Racial discrimination. Demur was discriminated against due to his religion, whose members are primarily African American. Objects that had to do with his ethnic background and skin color were left on his desk upon his return. Religious discrimination. Jenkins was unsure of the authenticity of Demur's religion when it was brought up to him, as it was different than the religion that he practiced and anything that he was familiar with.
Some laws related to this case include the Title VII of the Civil Rights Act in 1964. This law protects employees from discriminations from such as race, sex, gender, and religion. Religious and racial discriminations were both from superiors and coworkers in this case. Quotes such as, I'm quite the religious person, but this sounds quite strange. And even you must admit they do weird things. Both of those were by Jenkins, his superior. Another law is Section 11C of the Occupational Safety and Health by the OSHA Act. And that law states that it makes it legal that employers can retaliate against employees for raising concerns on issues including workplace health and safety. And retaliation can come in many forms from OSHA, including more subtle actions such as isolating, distracting, and mocking. And mocking was a big thing from Jenkins in this case.
So how Trenton failed to support and supported their equal employment opportunity policies. Trenton's EEO policies and anti-discrimination policies state that the company prohibits discrimination against an applicant based on their race, color, or religion. Demur was heavily discriminated against at Trenton, both racially and religiously. Demur was questioned about the validity of his religion, which is not allowed in the workplace. Demur was also harassed constantly by his coworkers for months. Coworkers called his religion strange and full of a bunch of voodooists. They also vandalized his office by filling it with dolls and chants titled "Prayers for Black Folks." These actions go against Trenton's EEO policies because the discrimination actively affected Demur's workplace, which affected his opportunities in the future. Jenkins also did not follow company policy as a manager and take preventative actions. Rather, he dismissed Demur, saying, "As an African American, you should have expected some light ribbing for your conversion to the strange religion." Lastly, Jenkins violated the company policy for hiring one of the members from his church instead of promoting Demur. The reason behind this decision is both racially and religiously motivated, as Jenkins has made it clear countless negative comments about Demur's religion, which is primarily made up of African Americans. This is against EEO policy, as discrimination has prevented Demur from receiving a promotion, which is not allowed under EEO policy. How Trenton supported EEO policy. Ford held a meeting with management and sent out a memo to employees clearly stating Trenton's EEO policies and possible consequences. Ford also continued to check up on Demur multiple times after the incident. Steps that could have been taken to avoid the problem. Management, specifically Jenkins, should have created a workplace culture based around diversity and inclusivity. Management should have created more avenues for employees to report discrimination. This will help avoid problems such as retaliation and silencing of the issue. Human resources should implement a system in the workplace that creates checks and balances to make sure all policies are understood and enforced timely and properly. This would both stop harassment against Demur and make sure that Demur was not discriminated against in the promotion process. HR should also require employees to participate in anti-discrimination programs.
Why it's going to be difficult for Trenton to argue that Jenkins evaluated Demur fairly. It'll be difficult for the company to argue that Jenkins evaluated Demur fairly because during the first interview process, Jenkins clearly set up precedents for how the future evaluations would be conducted. This included clearly stating the evaluations were based upon strength and productivity. On top of that, Jenkins discussed the importance of acting as a family. The article states Demur's abilities of high performance and productivity, as well as being well qualified and already part of the company. So Jenkins did not follow his own preset parameters for the evaluations on top of handing the positions to its church members.
Our recommendations for Dixon were to reach a settlement with Demur. By doing this, the company will relinquish their opportunity to defend the company's actions and admitting they could have done more once they were made aware of the harassment. However, they should reach a settlement with Demur to cover lost wages and emotional damages to avoid going through a court trial, which would be more expensive for the company.
Okay, in two similar cases, the EEOC sued Aurora Pro Services alleging religious discrimination and retaliation. Aurora Pro required all of their employees to attend mandatory prayer meetings. They failed to accommodate employees who felt that the prayer meetings conflicted with their beliefs, retaliating against them by cutting their pay and ultimately firing them. In another similar case, the EEOC sued Alto Construction and J.A. Cronson, alleging racial discrimination. Alto Construction and J.A. Cronson are two different companies with a similar problem. In both companies, management and employees made frequent use of racial slurs in front of minority employees. Minority employees were also looked down on and given the worst tasks, and when they complained about this behavior, they were fired. And the similarities between this case and the two EEOC cases that were chosen. Trenton employees questions Demur's religion, failing to accommodate for his religious views, similar to EEOC versus Aurora Pro. They also mocked him, both for his religious views and for his ethnic background, in similar ways to EEOC versus Alto and J.A. Cronson. Demur applied for and was passed over for a promotion. He alleged that this was a religious discrimination, as it was given to a member of the manager's church, and that it was also retaliation for him speaking up about his experience.
The financial impact on Trenton, because Trenton violated the Civil Rights Act of 1964, specifically Title VII, Demur may be entitled to any financial compensation for lost wages, medical expenses, attorney fees, and costs, or any of the other out-of-pocket expenses due to the situation with the company, which would impact Trenton financially, as the company would be the source of Demur's compensation. Also, Demur may be entitled to financial compensation for any emotional damages, humiliation of character, and harm to his reputation with the company.